regarding succession or on the application of this doctrine of representation in succession and partition of ancestral property, it is used for determining the legal heirs and for determining the quantum of share of an heir or a group of heirs. And this is all about the application of doctrine of representation, while the very law of succession or law of inheritance is applied to a deceased Muslim. And regarding doctrine of stripes, as per this doctrine, the where there are branches, the division of property takes place according to the stock. For example, at the places where branches bifurcate under the Hanafi law, no aspect of the doctrine of representation is recognized, but for calculating the shares of certain heirs, the shares apply both the above doctrines, and under Hanafi law, the heirs of a deceased Muslim, male or female, fall under the categories such as the sharers, the residuaries, the distant kindred, and lastly to the state. And the sharers are those relations by affinity of marriage and those relations of blood, while the residuaries may be descendants or ascendants and even collaterals, and the distant kindred are all those blood relations of the deceased who have not found a place either among the sharers or residuaries. These are the female agnates, cognates, both males and females. The best classification of distant kindred would be the descendants, the ascendants, and the collaterals. Lastly, if a Muslim died hairless, his property devolves on the state and it became a part of public treasury. And now we'll discuss the other two important doctrines relating to law of succession or inheritance under Islamic law. One is doctrine of all or increases, or doctrine of right, which is written. So, when the sharers given to the sharers are equal to the unity, no problem arise. But when the sum total of shares is either less than the unit or more than the unit, the problem of reduction of shares or the distribution of balance arises. So the above two doctrines are applied to solve the problem. Sunnis recognize both the doctrines, while the Shias only recognize the second doctrine, and that is doctrine of Rad or return. Under Shia law, the heirs of a deceased Muslim fall under the following, such as Nasab or Sabab. So, Nasab means to share law, blood relationships, and those all falls under blood relationships are called Nasab, and Sabab means the special relations like status of spouse or special legal relationships created out of marriage or any such relation which are legally or lawfully created under Islamic law. And now we'll found the very position in India regarding succession or law of inheritance. In India, the first categories are the heirs out of the marriage, and that only the husband and wife, and the second categories are the heirs by consanguinity, and which includes parents, children, and other descendants, grandparents, so also brothers, sisters, and their descendants, and so also paternal uncles, aunts of the deceased. The heirs in an earlier group exclude heirs in the latter group, and heirs in both the categories of a group inherit simultaneously. And lastly, to the state and become a part of public treasury if there is no legal heirs to a deceased Muslim. And in India, they don't recognize the distant kindred as a separate class of heirs. So, this is all about the law relating to succession or inheritance, as we found under Islamic jurisprudence and the very views of the Sunnis and the Shias, and as per the application for settling the claims of all legal heirs under doctrine of representation, doctrine of stripes, and doctrine of all, and doctrine of rod, and as per the very position in India among the Indian Muslims in relation to succession or law of inheritance applying to the very property or estate of a deceased Muslim. So, this is all about succession or law of inheritance as we found under Islamic law.